Just wanted to point out the information we provide today is of a general advice. If you do want some more information, please seek some professional advice.
Hi, welcome to the Retirement Living Podcast Your Way, where we have real conversations with Troy Theobald from RFS Advice. Today's session, we've got quite an interesting one. We're going to be having a look at the whole concept around legal documents, in particular wills, and if we get time we may even have a look at powers of attorney. And this is obviously all part of the Retirement Living Toolkit that Troy and the team at RFS Advice have built over the last number of months. And we often find that the whole legal side of things often can be overlooked. So we thought, well, why don't we actually bring in an expert for today's conversation? And I'm pleased to welcome Peter Muller to the podcast.
Thanks, Greg.
Thank you very much for joining us. And I should say, Troy, welcome. I didn't, you're looking across
at
me. I know.
Now.
Sorry, Troy. Yeah. You're a given. But look, Peter, you're obviously a partner at QBM Lawyers.
That's right.
Here on the Gold Coast.
Yep.
We've done obviously a lot of work, and you've done a lot of work with our clients over the years. So,
Yep.
do you mind just sharing with the listeners a little bit about yourself and the sort of work that you tend to specialise in?
Well, our firm is a general practice, but we do a lot of litigation and a lot of commercial work. And over the years, we've done a lot of estate planning and estate disputes as well. I've now been admitted since 1991, which is probably about 80 human years. Over that period of time, you come across a lot of issues. You see a lot of where things go wrong, and you try to work with that to try to avoid problems for people who come to see us.
Yeah. No.
Oh, there you go. He's finally admitted he's committed. I thought that might have been something that happened years ago from that. But where we actually work closely with Peter and his firm is exactly that last point of dealing with things before they're a problem. So we try to make that a priority when we're working with clients, is to deal with things in advance as opposed to dealing with them in arrears. And so often I'm going to get to that, it's going to be a priority, and people haven't had their say, they haven't put it in writing, they haven't thought it through or documented it. And then they walk in the door with an absolute problem, and I'm like, I'm going to send you over to see someone to fix this. You do need an expert. And from Peter's perspective, his words to me is always, well, I'd much rather people see me in advance and we can deal with these issues than arrears when it's very difficult. Then it's an argument.
Yeah.
That's right. Yep.
And I guess we were amazed when we're having a look at some of the statistics around, just even wills, when we're actually pulling together the information. And it's just amazing that one of the stats that we saw was nearly 50% of Australians over 55 don't have a valid will or an up-to-date will. Now, that shocked us.
Yeah, I have to say I was a bit surprised at that myself.
Right.
But I still do see quite a few people who don't have wills.
Yes.
A lot of people probably think that they don't need one if all of their properties, all of their assets are owned jointly. If something happens to them, then by and large it might end up with their wife, but or husband, as the case may be. But then it's just deferring a problem for later, because if they're the survivor out of that partnership, well then having no will means that there's going to be a mess when they pass on.
So can we just, I think it'd be worthwhile sort of starting at that whole, let's just take it up a little bit of a level here and probably simplify.
Yep.
The concept of a will. If you could maybe just sort of share with the listeners, I guess, what it is, what are some of the moving parts with it that might be worthwhile. And Troy,
we
you'll
get
have
so many people that we try to have this conversation. Have you got to work? And you'd think you'd ask them to go and donate blood or something.
Right.
They don't want to do. It's like it's okay. This isn't a big scary thing. Do we have this one? I'm sure there's no statistic in the world that's going to show because you create one you're going to use it tomorrow. But there's this weird aversion by so many people out there. And that's enough for them to go, I don't do it.
It's too hard.
I'm going to get to it.
I know. One of my brothers is a case on point. I've even prepared him one for nothing, and that was about a year ago, and I'm sure it's not signed yet.
Wow.
I think he. I wouldn't say he's superstitious, but I think it's sort of something that he just doesn't want to deal with, and I can't blame him. But it's the kind of thing that a lot of the time, as a parent or whatever, you might put off and put off and put off, and then you might decide to go on a holiday without your kids, and then you think, well, hang on, just in case this plane goes down, I'd better be prepped. And we do get that quite a lot. We'll get a call from someone who wants to make a will, and they're on a plane the next week.
It's urgent.
Yeah, well, I literally had one yesterday. Said, have you updated? No, we're getting to it, but we're going away in 3 months' time, so I've got a deadline I have to do it by. I'm like, okay, that's an interesting way to look at a holiday, but. Yeah.
Yes, I'm sure that there are a lot more plane crashes in people's minds than what there are in reality. But that does seem to be a big driver for people making wills. So just to get back to it, Greg, the idea of or what a will does is that it's a document where a person expresses, and it is binding, provided it's done properly, how their property is to be dealt with when they pass on. It doesn't really have any effect before they die, so it effectively comes into effect when they die. And the main things for what's needed by a will is to appoint the person who's going to carry it out. That's the executor. And so you appoint, and that needs to be someone that they trust. And then the second thing is to actually deal with your property. And there are all sorts of things that can go wrong in those two very simple concepts. And we might talk about those later. But effectively, if we have the executor and you actually properly dispose of your property, well, then that's what's needed. And then it needs to be signed, and it needs two witnesses. Now, in Queensland these days, lots of things can be dealt with as informal wills, like a text message, or you could write it on a scrap of paper, a voice recording, and that can actually all be put to proof by the Supreme Court to establish a will. But if it's not done properly, if it's not done in the usual format, everything costs more money to. So for example, if someone's trying to actually put a suicide note to proof as a will, which does happen, the costs of actually doing that might be $10,000 or $15,000 to prove it, and it might not be established to be a will. Whereas if the person had gone in to see a lawyer and had it done properly, well then it's really dealt with quite easily in most cases.
So with the appointing of an executor, do you often see single or multiple parties? Because I'm just thinking with...
Generally, most married couples will appoint each other to be the executor, and they'll give their estate to each other. And then they'll have a backup executor for if they both passed away.
Yes.
And because the idea is that you don't want to have a married couple where they have a will giving everything to each other, and then as soon as one of them dies, the other one's got to race in and have a fresh will done, because they're going through enough as it is. So we try to effectively have a backup executor, and in some cases that might be their kids. In some cases it might be friends, or sometimes it might be an accountant or a lawyer. Generally speaking, if I was preparing a will or making a recommendation, and it was that, I would have, if it's not going to be the kids who are the executors, I'd want two executors.
Yes.
For a few reasons, but one of them is because that gives a bit more oversight, because the executors have a lot of power and they have a lot of discretion. And the other is that it's not a particularly nice job being an executor. You get a lot of complaints. The beneficiaries all want their money straight away, and then a lot of the time there's squabbles amongst the beneficiaries.
Who would have thought?
Yeah,
families.
Yeah, we see that, and particularly in blended families, there's a lot of. There can be quite a bit of hostility, and a lot of resentment comes out, and so effectively being an executor can be the poison chalice, I think, like I would probably prefer not to be in most cases. So So yes, in a lot of cases, you'd have, say, husband to wife, wife to husband, and then you might have either the kids or some friends or your family members. Has to be someone that you trust.
Yes.
But bearing in mind that if you appoint a lawyer or an accountant to be an executor, well, then they're going to charge for their time.
Yes.
And that can actually get quite expensive, especially if the beneficiaries start to squabble.
Yes. Yep. Okay. And then what about what can be passed through a will? Because it's not just plain. Not everything can obviously go through. So do you mind sort of?
That's right. Yeah, that's a good. It's a good point, and I'll try not to overcomplicate it. But effectively, joint property for the most part. So if a home's owned as joint tenants, then it goes to the surviving joint tenant irrespective of what the will says. And a lot of the time joint accounts and jointly owned chattels, furniture and things like that, they just automatically go to the other person. So under your will, you can really only give away property that you own. And you get quite a lot of the time, people over the years have accumulated assets in other entities like companies or trusts, and their accountants have told them to do it. They've never really understood it. They treat it as their own property. Now, when they have their will, they think it's their own property. They might not tell their lawyer that this is actually owned by company XYZ, and they give it away in the will. Well, you can't really do that. And so you can only give away what you own. And things like superannuation, for example, which is a little bit different, that doesn't get dealt with by the will usually, or in a lot of cases it doesn't. And life insurance doesn't usually get dealt with by the will either. So it's really only property that you own.
And Troy, do you see a lot of, obviously when you talk about superannuation and death benefits and things like that, that sort of falls into your wheelhouse?
Yeah, it's getting it all to tie in, and that's well, I literally had a case. I was in Brisbane, I had to ring Peter last week on there just to make sure everything tied in, where we've done some of the shows on the hidden death duties inside superannuation, where all right, it probably makes sense if someone's got a terminal illness to take it out of super, it's going to go to adult non-dependent kids. Then it falls into the will though. So we've got to make sure that what they had in their superannuation actually fits with what their wishes were with the will, and that's generally at a time when you've got time restraints and everyone's a little bit stressed. And so it's just making sure all of those parts fit together, and it's way easier in advance than when you have a health issue and gee, I need to see you today and can you help me through this? Because it's not always easy to get the accountant or the lawyer together in a short period of time. I know in this sense we're chasing accountants, we're chasing to get it down. Thankfully we've seen copies of the will, we know exactly what it says, so we can see it'll fit with the wishes. But if people didn't have those copies and hadn't done that in advance, it'd be very difficult.
Yes.
And it's got to be done in a short time frame, and then people's families, they might have kids overseas, there's all sorts of moving parts to Peter's.
It's an emotionally charged time as well, isn't it? You're not doing it when things are...
Well, for just trying to put it into a simple example, if someone had $1 million in their super fund and they said, I'm going to give this to my children through a binding nomination in the super fund, which avoids the will, and then they had $1 million of other assets that they were going to give to, so they gave everything else to their wife. If the decision was made to take the money out of the super before death to avoid the tax, that would then go into a bank account and be part of the estate, and then would become all of the wife's property.
Yes.
And the kids would get nothing.
Yeah.
So and that kind of thing does happen from time to time, and because the money would get taken out of the super before death to avoid the tax on it, which sometimes could be 10 or 15%.
You can invest 17 on it. So it's a big amount there. So it's got to be very careful.
So if you look at things in isolation, that's where people are going to go wrong.
That's right. So the advice to have it taken out of super pre-death is actually good advice.
Yes.
But it's trampled on the on the plan that was made beforehand.
And to Peter's point, we've got it's the blended families tend to be more complex. We've worked on clients together where there'll be a trust left to maybe the son or daughter from the first marriage. The property might be going to the second wife, and then superannuation could be treated differently. So you've got to be very careful as to which way it goes. It's a great scenario they've set this out, but you just have to be aware if you're adjusting any of those structures or strategies, it's going to change the outcome. It may not be the outcome that they actually set up.
And that's probably coming back to when people are instructing us to prepare a will. A lot of the time, people kind of think of this as, oh well, look, I tell a lawyer, I tell them who I want the executor to be, and I tell who I want the beneficiaries to be, and that's all they should. It should be really a very simple process. And then we as lawyers are saying to them, well, look, we really need to know what your assets are, and we need to have a look at your superannuation, death benefits and things like that. And sometimes I think people would think, look, you're just overcooking it to get more fees. Mm-hmm. You're making this too hard. How much is this going to cost? And look, the issue is that if we're doing our job properly, well, then we actually do need to know all of these things, and otherwise you can end up with unintended consequences. And there's all sorts of examples of when that happens, but I won't bore everyone with them.
But I think it's it's a good point that, and I know obviously we work closely with yourself, and then obviously Troy, you mentioned calling Peter last week. I think when you've got what we do on our side, the understanding and of the position and so forth, then bringing you into that conversation, and then I think that works quite well.
Yeah, it's directing people when you recognise they need other expertise and need that advice directly from that person, not third hand from someone else.
That's right.
I think that's the key for whatever professional you're dealing with. If someone's answering all the questions on all the things, it's probably an issue. And I heard some of them, can you come up, sit in the room in the corner, but this isn't a me issue or advice. This is you going to the lawyer to sort that if you need it, just to make sure you're understanding and saying all the right things. That's fine, but really, to Peter's point, it's extracting that where things are is really important, as opposed to I've got a house, I've got some assets, got some shares. Particularly now, the high net worth people, where we're structuring things, we're using more companies for investments, just with changes to superannuation and everything there. The strategies where we want to leave potentially the shares in the company to the next generation, so we're not having to sell all the assets. Now that's got to be structured correctly, because the will would be leaving those shares and those assets to child A, B and C, and it needs to be structured. Otherwise everything could be forced to be sold, and a clever strategy had in place. If someone's got $7, $8, $9, $10 million, and we get 10 years down the track it's 15 or 20 million, that's a lot of tax to trigger if we don't need to.
And that does pop up quite a bit. For example, sometimes companies have a lot of assets, but the people don't want to take the dividends out of the company because of tax. And what could happen is that those shares, instead of being given to people, they could be actually given to a testamentary trust, and that would allow for distributions from those, and it can actually make quite a good outcome. I don't want to sort of make it complicated though, but so essentially we have our executor, we have our beneficiaries, and then we actually have backup beneficiaries. And so for a fairly simple will, if it was mum and dad and they have a couple of kids, you might look at having the executors each other. If they both pass on, then you generally have, if you had two kids, you'd probably have both of them as being executors. If you got three, it's always a bit of a quandary, because if you leave one out, well, then there's going to be an upset.
Yeah, definitely.
And so even though three's a bit cumbersome, I'd probably say stick with three, and don't have the drama that comes out of it later on, because if you only have two out of the three, the third one's just going to snipe at them forever because they're going to be upset about it. And then you would normally say, okay, well, look, the estate goes a third, and then you would consider, okay, if one of them passed on but they had kids, what would their share of the estate go to the kids? And some people say yes, and some people say no. It's
We've come across this a few
yes,
times. That's why I'm having a little
that's right.
chuckle of differing in opinions on what is fair and reasonable is different per household.
yeah.
So subjective, isn't it?
Look, and everyone's a bit different. And
absolutely.
I've had some clients who've said, if my son dies, his share goes to his wife, and which is quite extraordinary, because most of the time people sort of treat that as being the end of the relationship, so they're not family anymore. But yeah, and so I kind of assume that that's going to be the case, that it would actually go straight on to the kids. But every so often I'll have someone say, no, she's put up with him, so she deserves it. and so, she's a good mum,
yes,
or something like that. But so we don't take anything for granted.
Yes.
So you got that, and then sometimes you will have people who then go down a path and say, okay, well look, but we're a family, and so what if we're on a family holiday and all of us go down?
Yep.
And then you have questions about what happens to the estate after that, and that can actually create some issues as well, because you might say, okay, well, look, it can go to the parents, but which parents is it going to go to? What happens if they have a bust up, and this, that, and the other thing? And every so often you'll get someone who's very, very focused on this kind of thing, and I've had spreadsheets and all sorts of things put up to me. The more involved it is, the more expensive the will's going to be to draw.
Yes.
But generally speaking, that would be the kind of thing. I try to keep things as simple as I can, because the simpler it is, then the less likely it is that there's going to be a squabble later on. And
because you must see it all. I know we were talking about it last week, even about just wills and how complex, and how some lawyers will overcomplicate it. And you made the comment that you like to keep it simple, very thorough, and you make sure you've got all the facts and everything there, but you still don't need to make it too complicated.
I think our time's really spent in getting the information. The actual document that we produce might only be 2 pages long. Effectively, for a will that's going to be administered fairly quickly, you can really do everything you need to do in a couple of pages. So some of our pro forma wills are 15 or 20 pages long, but in reality, for most situations, that just makes the client feel better about paying for it. But then if you have testamentary discretionary trust wills, well, then they're usually quite big and involved.
So they're just trusts that come on the event of death. The trust is created.
A discretionary trust that arises on death, and they are they can be useful in some situations, and particularly if there's if the assets. If it's got to be managed over a period of years, that's a good thing to have. It's also good if you've got concerns about one of the beneficiaries having financial challenges, and people also tend to use them for to try and protect a gift from matrimonial claims.
But those ones are probably more complicated, and
that's always going to cost more.
Yeah, exactly, and they're probably ones that hopefully they've at least thought of that. What are your thoughts, and Troy, you can jump in here as well, because I know you've got a view on this. The will kits. Sorry, guys, I had to ask the question because
That'd be good for starting a fire with. But, I mean, it's a bit like anything. It's, we do a financial plan. Someone's never done anything, never looked at their super, never done anything, and they think they can retire and do it themselves. Yep. Or do you go to a professional who does it all day, every day? Like, it's the will kit. You're going to sit here and draft this document. I've had them there where you're the first question, they've got to be signed by, at least 2 witnesses there, and from that perspective, they can't be, mostly I think it's primary or beneficiaries under the will. Right. So half the time, I filled it out, everything goes to the kids, I got them to sign it. I'm like, you failed before we even started. We've failed in the procedural element. There's just so many of those that this is, someone said to me, it's your last chance to have your say in this life. And I really think, wow, for spending a couple of grand to have your whole life's possessions and everything you've accumulated dealt with to your wishes, that's, I don't know, it seems the best money you spend your whole life to me, but that's how I view it. Others obviously see it differently, because that's the last thing I think, wow, it's the cheapest, most inexpensive way I could deal with it. That's not what I'm thinking when I'm thinking of this.
No.
We do see, I've seen them before where they've been done properly. I've seen them before where people have gotten away with it. But then a lot of the time they're either not done properly, they're not signed properly, or beneficiaries witnessed, like as Troy said, or and what we also see a lot of the time is what they call a partial intestacy, where people give something to someone, but then if that person doesn't survive to take it, then it's not given to anyone, and there's no fallback and things like that. But if I haven't counted them, but I think I could write a blog article every fortnight about a matter going to the Supreme Court where people have tried to do a will themselves and have stuffed it up.
Yeah.
And look, any time that something's going to appear in the Supreme Court as a judgment of the court, it means someone spent a pile of money, and that pile of money, I think, would be an absolute minimum would be $10,000. I would have thought, to assuming that you didn't need evidence given orally in the court. Like, some of these things can be actually done on what they say on the papers by affidavits. But if you're talking a minimum of 10, the more likely result is several times that amount.
Yeah, wow. And you think that the person that's actually written the will, that would be the last thing on their mind, thinking that was either going to happen, and they'd be turning over in their grave thinking that this has potentially caused family issue. Like, to go to that estate, to that level, clearly there's issues going on, and the family dynamics have certainly changed.
Yeah, well, look, I had I was looking at a will not long ago where a very well-meaning and a very nice person, she'd prepared it for her brother, and anyway, so I've looked at the will, and it isn't a problem, because in this instance, the part of the will is right where it gives everything to the wife, so that's okay, and the wife survived. But anyway, she said to me that because I said, well, the wife's going to need a new will, and she said, oh, that's okay, I'll do it. I've done lots of these, and I'm really good at it. And I said, well, I can see four problems with the one that you've shown me. Look, I didn't want to be rude, because people do get very enthusiastic, and they might have ChatGPT helping them out with things, and they're probably very proud of their work. But what they've got to bear in mind is that a lot of the lawyers who are practicing in this field have been doing it for a long time, and a lot of the lawyers, we keep an eye on the judgments, and we see where people have gone wrong with things.
Yes.
And we're learning all as we go, and law changes quite a bit as well. And it's very, very easy to make a mistake with these things. And so, look, for the cost of actually doing it, and the cost of fixing the mistake, I would always say, look, go to a lawyer and get it. It's
I don't do my own plumbing. I don't do my own electrical, because I'd get a professional. Kind of think for your will,
I think it's even more important. So
I think it's more important than a light bulb. So
that's right.
But it's just sometimes people sitting back and thinking of that, because they can be well intentioned, exactly. But I can do this, but they haven't thought through the consequences at the other.
They wouldn't even know necessarily what questions to ask.
Well, that's right.
There's the answer of should they be doing it.
And that would be well, I was referred one just recently where a fellow has given away 2 houses in his will, or 2 units, I think it is. One to his son and one to his daughter, but it ends up that they're actually owned by a company, and they have been for donkey's years. Now, he actually doesn't have the ability to give away the houses because they're not his, they're the company's. What he owns is the shares in the company. And then to pull property out of the company to give to the people, he's got all sorts of tax and other problems. And so, that's going to need quite a bit of finessing to see these people achieve what they want.
Yep. Now, just in the interest of time, I just got maybe one more question that I think people might be thinking about, and that's keeping a will up to date. So, are there any sort of general rules of when you think people, if they've come and seen you and they've got the will constructed properly, when should they think about updating it? Is it a family event? Is it time? What are the reasons?
Look, I think it's not a bad idea, and we've started a program where we'll do an email blast to clients once a year. We don't want to annoy them, but it's really only several questions to think about, and it's essentially, well, have you had a matrimonial problem? Has someone had a health issue? So, say for example, if you got an executor who you might have mum and dad, or you might have dad as the executor, and dad could have had a stroke. Well, he's not going to want to be the executor anymore. It's a lot of stress to start with. Have you had a falling out with someone? Are you worried about one of your kids? Are you worried about them financially? You, for example, if you given half of your estate to a son and he's been made bankrupt, well, you've just, if you die, you've got a very, very happy trustee in bankruptcy, because the trustee in bankruptcy will take half of your estate. And I've had that happen before. We had to litigate to get out of it. So those sorts of things, it's kind of something that I'd probably say, well, just have a think about it once a year to make sure that what you've got is what you really want. And you could, for example, you could be giving half of your estate to your son and half to your daughter, but then you might have given your son $200,000 to help him buy a house. Now, that if you've given that 200, is that meant to be part of his gift under the will, or does he still get half of what's left over? And I can tell you that kind of thing happens all the time, because there's never any records kept anywhere, and daughter will always say, no, it was meant to be taken into account in the will, or it was meant to be a loan, but there'll be no record of that. So
actually, I'd love to get you back for another podcast discussion around the whole helping grandchildren or children and just some of the traps, because you would see that all day, every day.
It does happen. Family lawyers see a lot of it as well.
Yeah.
So yeah, but I'd generally say, look, think about it once a year. Every so often, I'll have a client say, "Oh, look, I need to check my will to make sure it's okay," and then they might come in and I have a look, and they don't need to change it. So. We won't change something that doesn't need changing, because for practical purposes, if someone's changing their will a lot, it's not really a good sign.
No.
Sometimes people get offended by their grandkids not paying them attention, or this, that, and the other thing, and so they'll want to change their will like once a year. It's not a fantastic look, I think.
Yes.
Because we all start to worry about capacity as well, about whether people are making decisions for the wrong reasons. So,
no, that's great. No, thank you. And I think obviously, Troy, in your world, it's something that I know we talk to clients about when you're going through it, making sure whether they've got the will updated, things like that's just part of what you do in part of the conversation. Would that be fair?
Yeah, you can't guarantee outcomes, but you see better outcomes where it's dealt with.
Yeah.
People know their wishes. We will keep copies of those for clients. We have been asked by some of the beneficiaries on this was mum or dad's wishes. Oh, okay. Look, generally people are more likely to respect and not challenge things when they know, it's well thought out, it's been considered, they've sought professional advice, and it's been laid out, as opposed to everyone thinks, well, I know mum wanted it this way, I know dad wanted that, mum wanted me to have the ring, dad wanted you to have the car. It's all those little things that. It's the craziest things that cause the blow-ups. And a lot of these are then lifelong family problems that could have been possibly avoided.
Yeah.
Yes, agreed. I've seen a fight over teaspoons.
Wow.
They were the little teaspoons with the little shields on the end of them. And and look, we were the executors of the will, and son and daughter went. They had a dispute over who should have belonged, and there was actually a fight over pot plants in the same matter. And look, the costs of actually administering the estate were probably 4 times what they should have been because of these squabbles over little things. We could barely believe it.
Well, if it was communicated and some of those conversations are had,
yeah,
you might not be in the situation. So, look, I think we've sort of run out of time. But look, Peter, thank you very much for joining Troy and I here today. It's been great to have you in the room, and we'll definitely get you back for some other episodes because there's lots of information and knowledge in your mind. So it'd be great if you could share that with us.
I love having the real expert.
Come on! I feel great here. I've got 2 of you here. It's brilliant. But for those of you that would like to reach out, obviously QBM Lawyers.
QBM Lawyers. Jess Murray works with me and Will. She's very, very good.
Fantastic.
And I do them as well. So, so we have quite a bit, and we have quite a lot on the website too.
Because you've got some great blogs and you do some fantastic articles which we often have a look at, and you did a piece for our own newsletter, the RFS Advice one recently, which was great. What
we try to do is to keep the cost down by letting people educate themselves from the website first, and then if they're prepped before they come to us, well then we can keep our conferencing down, and that keeps the cost down.
Yep. And the website?
www.qbmlawyers.com.au.
I think I could have even guessed that one. So there you go. So look, thank you very much for that. And I guess this sort of rounds up the whole legal piece and administration in the retirement toolkit that we've produced. There's further information in there if people would like to have a read, and you can obviously access that at rfsadvice.com, and the orange button up the top, download the toolkit, and you'll see that. So stay well until next time. Thank you.
Thank you.
Thank you.